Greetings, Doctor. We are from Group 4. We are presenting BTMP 2073A Business Law Group Assignment. The title of our group assignment is Agency Law in Malaysia, Duties, Rights and Liabilities of Agents and Principals in Business Transactions.
Good morning to Doctor and everyone. My name is Yuan Ting. I will present introduction and problem framing of our topic, which is agency law in Malaysia. Agency law governs the relationship between a principal and an agent in business dealing. In practice, principal appoint agents to facilitate transaction, negotiate agreements, and manage business method. This help improve efficiency in business operation. In Malaysia, agency law is governed by the Contract Act 1915. An agency relation exists when an agent is authorized to act on behalf of a principal. The agent action may legally bind the principal even if the principal is not directly involved in the transaction. However, several legal issues may arise, especially regarding the scope of the agent's authority. This include actual authority or apparent authority. Problem may occur when an agent acts beyond their authority or when there are misunderstanding. There are also issues involving in duty, right, and liability of both the agent and the principal. Therefore, this assignment aims to examine the key legal issues relating to agency law in Malaysia, supported by relevant legal principle and case law. Thank you.
Greeting to my lecturer, Dr. Sabri. I'm Liao Zishen. I'll present the four primary legal issues under the Contract Act 1950. Primary issues are the fundamental questions we must answer before discussing remedies. Issue 1. Does this agency relationship exist? Section 135 defines it, and Luke Karen says the label agent is not enough. The court looks at the true nature of the relationship. Issue 2. Did the agent breach fiduciary duties? Section 164 to 169 require the agent to follow directions, exercise skill, render accounts, communicate, and avoid secret profits. Issue 3. What are the agent's rights and liabilities? Rights under Section 172 to 176 include commission and line. Liabilities. The agent is generally not personally liable, except in 4 situations. Issue 4. Is the principal bound? Has agency terminated? Section 180 and 183 says the principal is bound. Section 154 lists termination methods, and Merber-Hille confirms reasonable notice is required. That's all from me. Thank you.
Good morning, Doctor. My name is Shamunyet. Now, I will be presenting the secondary legal issue in agency law in Malaysia. Firstly, agency can be created through methods such as express agreement, implied authority, estoppel, ratification, and necessity under Section 135 to 140 of the Contracts Act 1950. This method helps determine whether a valid agency relationship exists. Secondly, the scope of authority determines whether the principal is bound by the agent's actions. If the agent exceeds the authority given, liability may shift to the agent. This issue is governed under Section 139 to 141. Thirdly, agency may be terminated through agreement, completion of business, operation of law, or renunciation under Section 154 to 161. This affects whether the agent still has authority after termination. Lastly, liability involving third party determines who is legally responsible in contractual transactions involving the principals, agents, and third parties under Section 179 to 183. In conclusion, these secondary legal issues are important because they help explain authority, termination, and liability in agency relationship. That's all for secondary legal issue. Thank you.
Hi, my name is Anin Tan. Today I will present the legal analysis on duty and right in the agency relationship. First, both the agent and principal have duty under the Contract Act 1950. The agent must follow the instruction, act carefully, honestly, and keep proper record. The principal must pay the agreed commission and protect the agent of lawful act done within authority. Next, both parties also have a right. The agent has a right to receive payment and indemnity. The principal has the right to accept loyalty, obedience, and proper conduct from the agent. If either party fails to perform their responsibility, legal action may be taken. In conclusion, agent law protect both the agent and principal by giving them legal duty and right under Malaysian law. Thank you.
Hello, my name is Ihan. I will explain the liability part and criteria discussion part. In the liability part, the issue is whether the principal is binding for the action of the agent or the agent may take on the personal liability for his action. Okay, you need to ask yourself two questions. One is that the action authority are given by the principal? If yes, the principal will take on the liability. If no, the agent will take on the liability. The second is that the agent has the ability to perform the designated task. It means that the agent doing well his task. If no, the agent will take on his liability. Okay, next we move to the critical discussion part. Although the Contract Act 1950 provides a comprehensive legal framework for agency law, there is still have some issue. First, the duties are not easily to carry out, especially in the situation of information asymmetry or lack of oversight. The agent may still do the action against the principal interest due to the personal gains. Second, while the law grants principal and agent certain rights, it may not always guarantee the actual protection of interest in practice. For example, even if the principal wins a lawsuit, the agent may not have sufficient financial resource to compensate for the loss. Thus, the principal may still be liability if the third party reasonably believes, based on the principal action, that the agent has authority. While this helps the protect the third party and promote the transaction security, it also increases the principal risk. That's all for me. Thank you.
Greetings, Dr. My Ong Sin Hui, and now I'll explain about our strategic recommendations. First, companies should use written agency agreements. This helps clearly define the agent's authority, responsibility, and fees, so misunderstanding and disputes can be avoided. Second, principals should use control appellate authority by informing third parties whenever an agent's authority changes or is revoked. This reduces the risk of unauthorized actions. Third, companies are encouraged to use digital audit trails. Proper digital records can be improved in monitoring, accounting, and communication between both parties. Fourth, regular legal actions and seminars should be conducted. This helps principals and agents stay updated on their legal duties and responsibility. Fifth, contracts should include dispute resolution or ADR clauses. ADR provides a quicker and lower cost method to settle disputes compared to court proceedings. Lastly, companies should also provide agency law training. This can improve understanding of rights and responsibility when dealing with the parties. That's all for me. Thank you.
Good morning, Doctor. My name is Tun Wei Ying, and now I will conclude our topic on agency law in Malaysia. So, overall, Malaysian agency law play a crucial role in maintaining proper business relationship between principal and agent. The Contract Act 1950 provides a comprehensive legal framework that governs the authorities, duties, rights, and liability of both parties in the business transaction. So, throughout this assignment, we found that agents are required to act honestly and carefully within the authority granted by the principal. Not only that, if both parties fail to fulfill their obligation properly, some issues like negligence, breach of duty, and apparent authority may lead to legal disputes and financial risks. Therefore, a clear agency agreement and compliance with Malaysian agency law are important to reduce disputes and ensure smoother business transaction. By understanding both parties' legal rights and obligations, principal and agents can strengthen the professional relationship and promote legally secure business activities. That's all from me. Thank you. Okay, now I have a simple case question to ask which related to the agency law. If Thomas appoints Jayden to sell his car for 50,000 ringgit Malaysia, but Jayden sell it for 60,000 ringgit Malaysia and keep the extra 10,000 ringgit Malaysia without informing Thomas, so what legal issue may arise in this situation?
For question 1 answer, the main legal issue in this case is whether Jayden, as the agent, has breached his fiduciary duty to Thomas, the principal, Under Malaysian agency law, an agent must act in good faith and must not make any secret profit. In this case, Jaden sold the car for 60,000 ringgit but kept the extra 10,000 ringgit without Thomas' knowledge. This is a breach of fiduciary duty. Therefore, Thomas is entitled to recover the 10,000 ringgit and may terminate the agency relationship.
Next, question 2. Farah appointed Jason as her agent to purchase goods for her business. Before the purchase was complete, Farah revoked Jason's authority. However, the supplier was not informed about the termination and Jason continued to enter into the contracts with the supplier. The question is, who will be liable for the contracts under the Contracts Act 1950?
Question 2 is about liability after termination of agency. Farah appointed Jason as her agent to purchase goods for her business. However, before the purchase was completed, Farah revoked Jason's authority. The issue here is whether Farah is still liable for the contract made by Jason after the termination of the agency relationship. Under the Contract Act 1950, termination of agency is not effective against third parties who have no notice of the termination. So, in this case, the supplier was not informed that Jason's authority has been revoked. Because of that, the supplier reasonably believed that Jason was still acting as an authorized agent. Therefore, the contract entered into by Jason may be by Farah as the principal. So, in conclusion, Farah may still be liable because proper notice of termination was not given to the suppliers.